On Bobby Joe Scott, from what you've told me, it appears that you've got him up pretty tight.
I think we do. I explained the facts to you the other day, and I've had a chance also, by the way, to check to be sure he had no prior record. He has no prior record, so we would be willing to recommend a 2-year probated sentence if he wants to plead guilty.
Bobby, I'm Jim Finstrom. This is my bar card. I've been appointed by Judge Scales to represent you in the case you've got pending against you in his court for breaking and entering a motor vehicle. I've talked with Winfield Scott, the prosecutor, before I came up to see you on this case, and he has advised me of certain of the facts that he had at his disposal that he could tell me without prejudicing himself. What I'd like to do is tell you what...
This man has been arrested and charged with breaking into a parked car and attempting to steal a gun from it. He may never face a jury for his crime.
Were you intoxicated to the point where you didn't know what you were doing?
No, sir.
Did you know what you were doing?
His crime, like the vast majority of others in Dallas, will be dealt with out of court by a negotiated deal between his attorney and the district attorney's office.
It's called plea bargaining or sentence negotiation or copping out. Whatever you call it, it is the unquestioned workhorse of the criminal justice system here in Dallas and almost everywhere else for that matter.
I'm afraid the phrase plea bargaining has some insidious connotations that are not based on fact. Bargaining goes on in all systems of justice, including the civil system. In the civil system, it's called settled out of court.
80 to 85% are worked out on a plea basis, where a person pleads before the judge and a sentence is set somewhere between the minimum and the maximum, usually agreed on between the attorneys in advance.
A full 85% of all criminal justice in this county is dealt with by this simple process of judicial horse trading. Without it, the criminal justice wheels here would grind to a swift and certain halt.
You see, each one of our felony courts dispose of around 1,500 cases per year. Last year they averaged just under 1,500. They averaged 100 jury trials per court. Now, if you're going to let everyone go to a jury, that means you'd have to have 1,500 jury trials.
Each Friday they are herded through the criminal courts like cattle, hundreds of them, each with his own bargain to cut with the DA. Once a deal is arranged by the two attorneys, neither the judge nor the defendant have to agree to its terms, but most often each does.
Anybody that pleads guilty really gets a bargain here. I mean, there's nobody pleads guilty unless it's a little less than they think a jury would give them.
Very probably the great majority of the cases would have the same punishment as they would if they came to the judge for sentencing all the time.
You call it plea bargain or whatever you want. If a person pleads guilty, he gets less than what he thinks and we think a jury would give him.
Bobby Joe Lynch, case number C733638KN. Mr. Lynch, as we talk, speak out where the court reporter can hear us, will you please?
Yes.
You're charged by bill of indictment returned by the Dallas County Grand Jury to this court with the offense of unlawfully breaking and entering into a motor vehicle with the intent to commit the crime of theft. Do you understand what you're charged with?
Yes.
Mr. Finstrom has advised me that when you are arraigned and when the indictment is read to you that you intend to enter a plea of guilty. Is this correct?
Yes, I do.
Are you pleading guilty because you are guilty and for no other reason?
Yes.
Are you pleading guilty of your own free will and accord?
Yes, I do.
Has anyone placed you in fear, promised you anything, threatened you, coerced you, or done anything to you to cause you to plead guilty in this case where otherwise you would not have done so?
No.
And you're not pleading guilty because of any delusive, persuasive, or false hope of pardon or parole, are you?
No.
All right, I warn you that if you persist in pleading guilty and the evidence proves your guilt beyond a reasonable doubt that the court will find you guilty.
So plea bargaining is the grease that keeps the all too often rusty wheels of criminal justice in this county well oiled and spinning. Still, there are those who worry that in our rush to expedite justice, we've shoved many of the rights of the accused under the rug. That brings us to the cop-out man.
He's the fellow from the DA's office who visits recently indicted prisoners and attempts to bargain a plea with them, most often before they've had the benefit of legal counsel.
Well, in the past, the plea bargaining has been done by a district attorney's man who came to the individual in jail and offered a deal where you can either plead guilty to perhaps a lesser crime and be on the street tomorrow, or you can wait around 7 months or 6 months for a trial, and we've been getting 50 years on this type of case when we try it. This leaves the individual on the horns of a dilemma. He may be constrained to plead guilty to a crime that he's really innocent of because he can't afford to lay around in jail for a long period of time.
Nobody's sure whether that's a violation of the constitutional right to fair trial, but Federal District Judge Sarah Hughes got worried enough about it last year to ban cop-out men from the county jail.
At present, no one from this office interviews any prisoner except on written request from him. The first question is whether or not he has an attorney or not. If he has one, the interview is terminated at that point and any discussions is had with the attorney. The next thing, if he doesn't have an attorney, provisions are made to bring him to court to appoint him an attorney within a day or two, whenever the judge will do that. And they have an agreement on certain days a week to bring him down and appoint an attorney. The only other thing, they tell the defendants, you don't really work out a plea at that time, but they can, some of them do, tell them that you're likely to get probation, or you're likely, if you plead guilty, we'll recommend 2 years, 5 years, 10 years, or something of that kind.
So the prisoners now have to sign visitor release forms, as they would for any visitor, before the cop-out men can see them. But the point is, the DA's men still have access to the prisoners, often before they've consulted attorneys. Thus, the ominous possibility that a man may be railroaded through the judicial system without really knowing his legal rights lingers. Other dangers in the system are more subtle and more sinister.
The problems with the plea bargaining system are not that there's a bargain per se, but rather that it occurs in a kind of a secret, invisible atmosphere.
The danger would be where you have an attorney on either side that could not properly evaluate his case.
That individual who's involved in plea bargaining is still, by our traditions, innocent until found guilty, so his rights need protection, and in many cases, the rights of that individual are not being looked after by somebody who's knowledgeable about the system.
Certainly he should. I think most people would agree he should have that right in law, the right to have the lawyer there and participating in the plea bargaining. But I don't think that's the law. I think it's at least questionable as to whether or not he does.
Any system of justice and sentencing has its imperfections. The only alternative is to let everybody face a jury, and I think you're familiar with some criticism lately of juries giving too high sentences.
We don't do it just because it disposes of cases. We do it because it disposes of cases in a fair manner. And Mr. Fenstrom, in your opinion, does your client know right from wrong and the nature and consequence?
It's not that plea bargaining is an evil system per se. Indeed, it is most often a good and just system. The rub is the potential for injustice.
The court accepts your plea and finds you guilty on your plea and on the evidence, and sets your punishment at confinement in the Texas Department of Corrections for a period of 2 years. The court grants your application for probation and suspends the imposition of sentence and places you on probation for a period of 2 years, subject to the terms and conditions of probation. Thank you, gentlemen. Good luck to you, Mr. Lynch.